Hello, everyone, to this session of the Budget Podcast, where we will be discussing the changes brought about with respect to dispute resolution slash tax litigation. And I will be in conversation with my colleagues Ashish Sodhani and Shipra Padhi. So, the first change that I want to discuss is how the budget seeks to completely revamp the scheme with respect to reassessments and income escaping assessments. The one of the major thing that they seek to do with respect to that is to reduce the time limit for reassessment proceedings from 6 years to 3 years and 10 years in case of search related cases where usually there is a malified intent. And the other important change there is that they want to change the standard for reassessment proceedings from there being a reason to believe to there being information which suggests that income has escaped assessment. So, Shipra, what are your thoughts on these changes?
Sure. I think the first one, which is reduction in the time limit from 6 years to 3 years, that of course comes as a welcome move, and it's a great relief to the business community. It does provide the much needed certainty to taxpayers, especially in situations where there are share transfers by a malicious seller and tax indemnities are negotiated between the buyer and the seller. A major point of discussion and negotiation is on the limitation of the time period. Now that it has become 3 years, this will be a point of relief for both the buyer and the seller. On the second point of changing the standard from reason to belief to information received by the CBDT or from the CAG, this does bring about some amount of objectivity, but the question is that does it result in the quasi-judicial function of determining whether income has escaped assessment or not, whether that function is being taken away by taken away from the tax officer. And the second issue is, of course, in what circumstances can the taxpayer question the information on the basis of which a reassessment is being made? And, what are the kind of criteria on the basis of which, certain information is being correlated to a reassessment proceeding? So these are, questions that remain unanswered, and one will have to see how the provisions pan out in the future.
Thank you so much, Shipra. I think with that, I want to move on to the next change, which is that the budget seeks to bring about something called a dispute resolution committee, where the idea would be for the small taxpayers to be able to approach the income tax authorities and get their cases settled, as opposed to undergoing the entire litigation process. So, Ashish, your thoughts on that?
Sure, thanks, Afan. So, like you mentioned, the DRC has been introduced this year, and it is only for small and medium taxpayers, and also with another caveat that any search and survey and requisition cases would not be eligible for the DRC for settlement. Therefore, the scope of DRC has been quite limited, as opposed to a Vivad Se Vishwas scheme which was introduced last year. Other than that, I think at a more higher level and a macro level, I think a couple of points that we need to keep in mind when a settlement scheme is put in place. One, that settlement requires concluding computations, appreciating merits of the taxpayer, and the other point being that there should not be any bureaucratic delays which could hamper the taxpayer's incentive of going under the scheme. Hopefully, this scheme should provide some benefit to the small and medium taxpayers, and they should be able to take benefit of the scheme like they were doing under the Vivad Se Vishwas also.
Thank you. Thank you so much, Ashish, for your thoughts on that. The next change that I would like to discuss is to bring about the faceless ITAT, and this is of course in continuation of the government's effort to reduce the interface between the taxpayers and the tax authorities. So, Shipra, your thoughts on the faceless ITAT?
Sure. So I think the first thought is, of course, in a faceless ITAT mechanism, written submissions become important. Secondly, today it's not clear whether oral hearings can be requested by either party and to what extent the tribunal is willing to grant this request. There are certain heavy and complex matters which are best explained in person, and losing out on this basic right may even constitute a violation of principles of natural justice. And during the lockdown and during the pandemic, we have seen tribunals have virtual hearings, and this difficulty has come up even during these virtual hearings. So again, it's something that we have to see how it pans out in the future.
Thank you so much, Shipra, for your thoughts. So that was it on the dispute resolution front. In case you guys have any questions, please do write to us.
Thank you.
Thank you.
Thank you.